Okay, great. So could we have everybody sit down, please? One of the wonderful things about meetings like this is that what happens in the coffee breaks and the informal discussion is every bit as interesting and lively and wonderful as what happens in the formal session. But we do want to have a chance to hear from as many of you as possible. And we want to start with our wonderful commentators from, let's just say, a more youthful perspective. So did you want, Horacio, did you want to say a word?
Let me just introduce them. Well, the idea now is that the floor is open. Everybody can speak. There are two mics there, and one here to the left, the other one to the right. And our both commentators, Francisco Rogero from Argentina and Minow, with a name that I did not yet know by heart, which may be excused because of this. Minow is a law student in the Harvard faculty, and he comes from Nigeria, right?
Nigeria, yes. He has a lot of fans.
Francisco Rogero is a practicing lawyer in Buenos Aires and has been within the young lawyers of the IBA until very recently. Now he had to quit that part of the association. But when I invited him to come, he was still there. So that the idea is that we start with Francisco,
yeah,
and then
go to
Minow, and our panel is going to answer questions, comment, and then the floor is totally open for everybody. Can you start, please, Francisco? Thank you.
Yes, sure. Thank you, all of you, for your brilliant speeches. Very interesting, and certainly they trigger many discussions. It's a privilege for me to comment on your speeches on behalf of the Young Council of the Latin American Regional Forum. I would like to share some thoughts from my notes that may turn into questions. We are talking about globalized profession, the role of internet technologies, and we can think of a parallelism between Romans and internet. Romans, when conquering the world, imposed a common law on all their empire. Well, my first thought is perhaps internet and technologies will finally impose a common law, and they will impose a common law for lawyers. Think of the WTO, who is looking into the legal profession and thinking in regulating them. And still, for example, in Argentina, we are trying to protect the law profession by banning foreign lawyers to practice law in our country. Does it make any sense? Is it important where the lawyer is physically present? Isn't the same if the lawyer is physically present or virtually present? Don't we have to start thinking of a world that is changing every second? And here's my second thought. We are a traditional profession, and that is great. But we have to be aware that changes nowadays are faster than they used to be. Now we cannot say, okay, we will analyze that and see if in some years we make the change. No. If you don't change now, you will fall out of the world. So be aware. If you have to change, do it now. The speed of technologies sets the path of our profession, and it happens with others, and we can be left behind. And a third and final thought related to technologies and virtual law firms. David said many times in his speeches that the common complaint of clients is that we are too expensive and that we don't understand their businesses. Well, that's very interesting. Last year, we organized a conference at my bar association between in-house lawyers and private practitioners. And I remember the general counsel for LATAM region of a big company saying, well, I do like your offices, your paintings, your perfectly dressed staff, but I don't want to pay for them. I don't mind where are you working. What I want is the best service, timely delivered, and not expensive. And I think that, again, we must start thinking about that. We are traditional, but perhaps our clients are not looking for that. They just need our specialty. We are not anymore their family doctor. David talked about unbundling services. Indeed, our clients are becoming sophisticated, so they look for the right lawyer for each matter. Well, there were lots of very interesting topics that were tackled by the panel in an excellent way, but I think we have to devote some time for the debate, and so I leave here my comments and pass to Minow.
Thank you. Thank you, Francisco.
Well, thank you so much, David, for giving us this opportunity to share our thoughts with you. I can't imagine being asked to speak after David and all the excellent speakers, but this is Harvard. They give opportunity for their students to talk. And on behalf of the students, I would like to say that we are really delighted to have you here. And we all want to be like you when we grow up. So, and I want to say also a very warm welcome to our Nigerian contingent, the Nigerian Bar Association. Mine is, so I have a paper with many points, but they have all been preempted by David and his panelists. And I used to have this friend who will say, whenever anyone makes an intelligent point in a conversation, that is exactly what I wanted to say. So most of the things you mentioned are exactly what I wanted to say. But I will make 3 quick points and then ask 3 questions. And I hope you don't have to answer them, but there are questions that are worth considering as we discuss this particular topic. The first point is on technology and its impact on the legal profession and legal practice. My observation in Africa, and I've traveled to many African countries, is technology is not only changing the way we practice law, but it changes the way the courts are operating. The emergence of areas like e-filing, e-payment, e-discovery are pushing lawyers actually into accepting technology and into adopting into that kind of practice, meaning that there may come a time when the courts, as we know them today, will no longer exist. Perhaps maybe you will just record your submissions at home and email it to the judge. Perhaps that may be a prediction that may come to happen. The second point that I want to make is technology is changing not only the way we practice, but also the way we learn and the way we teach law. I encourage you to talk to the students here, and you can see evidence of technology in this room. We have other colleagues in other rooms watching what we are doing, courtesy of technology. And the question now becomes, as we move forward with different law schools, trying to bridge the knowledge gap that exists between the rich global north and global south, one thing that technology does, it bridges this gap in terms of access to knowledge and in terms of teaching. Harvard is yet to start offering online courses, but there are universities that are doing LLM in online, meaning that technology is revolutionizing the way we are learning law. And perhaps in the future, there may be a version of IBA conference which may be conducted online as people in different parts of the world have access to the internet. My third observation is about the risk that technology is posing to the legal profession. Shakespeare famously remarked that let's kill all the lawyers. Nobody is killing the lawyers, but technology is killing some of the work that the lawyers are doing. And almost run out of time talking to me?
No.
Okay. Technology is killing some of the work lawyers are doing. As you can see, and you know it's part of your work, some of the repetitive jobs that we do at the law firms can now be done by computers. And then meaning that what is the future of young lawyers who are going into law firm doing the jobs that now can be done by computer and by technology. But the advantage also of technology is there is now a narrowing gap between big law firms and small law firms. A small law firm with a big and beautifully designed website can attract as much clients as a big law firm with big offices. These are the 3 comments that I want to make, and then I go to the most difficult part, which are the questions. One is we talked about how sophisticated the legal profession is becoming and how globalization and economic changes are really making things happen, especially in places like Africa where we are having growth. What role is the legal profession and lawyers playing in promoting inequality? Because the more sophisticated lawyers become, and the more they ally with the business interests, the more they promote growth, but there may not be equality at the bottom of the ladder. And then the question is, to what extent is technology affecting access to justice, and in what way are lawyers really helping towards promoting this inequality? The second question, which I think is worth considering, is we talked about the changing nature of legal practice and the need for legal education to adopt. We now know that it's not enough for a lawyer to know the law. He should also be very conversant with business and other things that is happening. How do we teach lawyers to think like lawyers and also to think like businessmen without converting the law school into something else? Do we ask lawyers to go to business school and have MBA, or do we have people with MBA to become lawyers? How do we do that? And we talk about the need for us to adapt to modern technologies. Who will design these technologies? Is it lawyers that will hire programmers to program for them? Or is it programmers that will hire lawyers to do the work for them? And what are the ethical issues involved? And finally, as I round up, we talked about different and multiple innovations that are going on in places like Canada and Australia about unbundling of legal services, alternative business structures, virtual law firms, outsourcing, offshoring, ghostwriting. These are all practices that in many parts of the world actually are unethical, and the regulations are against them. So since we have more liberal rules in some countries and less liberal rules in other countries, how level is the global level playing field in the legal market is? How is a lawyer from Africa going to compete with a lawyer from the US and from Canada that have different standard of rules? So as we think of moving forward, these are questions that we need to ask ourselves. Somebody came to me after David have spoken and the dean and said, I wanted to go to Yale for my LLM, but I think I need to come to Harvard if these are the kind of professors you have. So I want to assure you that the Harvard students are really happy to have you here. And we have many people like David here who are doing really interesting and amazing work. And I look forward to speaking and talking to many of you. And if you have questions about the school, feel free to ask me or any of my colleagues. I wish you a wonderful stay here and a safe trip back home. Thank you.
Thank you. Thank you, Francisco and Amino, for this excellent comments, and I think I'm going to give the floor to our panelists for them to comment a little bit on what they just said. Before that, nevertheless, there is a small a bag, a Congress bag was found with wallet and credit card inside. And we took the liberty of seeing the name of the credit card owner, and it is Miss Angel Ushe. So U-C-H-E. If you know her, please let her know that Elaine has her wallet. Elaine, who's there. That's a serious matter because the wallet is there, and she's probably desperate looking for her credit card. So Elaine has the bag of Miss Ellen, Angel Ushe, U-C-H-E. Okay? Thank you very much. Can I give the word to you, David?
I'll say just a few words about those wonderful comments. You've heard from me too much, and I really want to hear from all of you. I just want to encourage people who want to ask questions to go to the microphones, because otherwise no one will ever be able to hear what you have to say. So as we speak, you should go to the microphones if you want to ask a question. I'll just address the first of the three excellent challenges that Aminu raised, and he's my advisee on his spectacular dissertation on the growth of African legal education. So one day he'll be speaking to you in a meeting like this that'll be very, very important. I think the question he raises about whether the growth of sophisticated legal professions in many countries around the world will either mitigate or increase inequality is a very serious question. And we know here in the United States that although we have more lawyers, actually, when Jonathan said there are 1 million lawyers across all those countries, we have 1 million lawyers in this country. And yet, we also have tremendous inequality in access to legal resources, and that inequality is increasing over time. So there's a very interesting study which looked at the percentage of lawyers who devote their attention to individual matters of individual clients and the percentage that devoted it to business matters for business clients. And in 1975, it was about 50-50 between those two parts of the bar. By 1995, it was 2/3, 1/3 in favor of business. So as the legal profession grew and became more sophisticated, also the percentage concentrating on business increased. And I think this, you can see, could happen around the world. I think that's why, as we think about law, we cannot lose sight of those parts of law that have to be dedicated to the fundamental norms that Gopal spoke so passionately about the legal profession and about its commitment to the rule of law and access to justice. It's why this global pro bono conference that we're putting on is so important. But it can't just be pro bono. It has to be the way in which lawyers view the public interest and the public responsibilities as part of their jobs, even as they serve private clients. This isn't an easy balance to make. I don't pretend that it is, but it's a critical balance to make if we're going to have the kind of legal profession develop in these really wonderful and important countries around the world that help them to solve the fundamental challenges that they all face, and we face here in this country, around inequality.
I think I would like to add a footnote to what David, I think it's an absolutely brilliant point that even though you may serve private clients or corporate clients, there is an element of ethicality which is involved in the relationship between the lawyer and the client. Now, one of the things which I would like to respond to is that if you look at law as somewhat synonymous with business, I think the implications are very serious. And that is the point we should be concerned with. Whether you can have different structures which are helpful in cooperation, in pulling together resources, pulling together technology, is one aspect of the matter. But if you were to treat it exactly as if it is a pharmaceutical company, or if it is a company which is going to produce goods or services, the maximization of profit, which would naturally be reflected in the billing hours and the standard of fees, is going to impact, shall we say, the fundamental ethos of the profession. And this is a very delicate task, but it has to be borne in mind. And the thought that, well, I don't know how good this is going to be, but if suppose you have joint stock companies of lawyers and the shares are going to be held by some tycoon in the Middle East or in Cayman Islands whose face you've never seen, and he's going to trade the shares of this company on a stock exchange, I think the commodification of lawyers is a very serious danger. And I think that note of caution which, David, you've very rightly sounded is absolutely essential.
Any other comment from the panel?
Yes, just very briefly on technology and access to justice. I spoke quickly before. The Find a Lawyer 1 and Find a Lawyer 2, which I mentioned, the reason it is publicly funded is because it's aimed at citizens and because the European Commission wants citizens to be able to find lawyers, and according to language and practice area, and also because the European Commission wants citizens also to be able to partake in electronic proceedings. I didn't speak about this, but the tests which are going on at the moment under what I'd call Find a Lawyer, in fact, also involve non-lawyers. So in the area of small claims, as one example, citizens will be able to themselves conduct electronic proceedings online when this is built. And so, without question, technology will aid access to justice.
I'll just add that I think this issue of trying to ensure a level playing field and that lawyers from different cultures have equal opportunities is something that, at least in my experience, the IBA has been very concerned with. And one of the things that I'll mention, for example, is the Council's resolution on skills transfer in the context of the WTO GATS negotiation. And one of the premises of it was that as markets liberalize, maybe what you should have is an exchange so that you bring everybody up to the same level of capacity. It's really a capacity building concept, and I think this is something that's really quite valuable that the IBA has endorsed and that everyone needs to keep in mind.
Thank you, Laura. Well, we have here already 3 people that want to make questions. The first one is Mr. Praveen Parekh, who's a senior advocate at the Supreme Court in India.
Thank you. In fact, the various talks have given a lot of ideas. Has the legal profession, as we have traditionally understood, dead, or is it going to die very soon because of commercialization, because of globalization, because of technology? And if that is what can happen, I would think that let us think of having those advocates who will argue before the courts and tribunals, and other lawyers who will not be arguing, and in that you will have to then join the financial experts, the chartered accountants and things like that. And what we, the lawyers, as we today say, is an officer of the court. His primary duty is to the administration of justice, a noble profession, etc. But if everything is going to become commercial, shall we think of dividing them into 2? And one category will have different regulations and different regulators. Other category will have different regulations and different regulators. Thank you.
Thank you, sir. Who wants to comment on that?
Good. Yeah. I think there are already different models of lawyers practicing in markets. I see people here from Finland and Sweden where, in fact, non-lawyers can do everything. And, in fact, lawyers continue to thrive there. And not only that, but I said, in Finland, that the Supreme Court was called, really, for more lawyers to be involved because, in fact, as I understand it in Finland, anybody can argue a case before the Supreme Court, but the courts don't like that because it fouls up the proceedings. So I don't think that lawyers have anything to fear in an open market. It's obviously, structures may change, but the values which lawyers offer are shown in those countries I've given you where there is no reserved activity, show that lawyers continue to thrive. So it's provided we stay true to our values, I see no threat.
The comment that I would add is that I think that it would be useful if all of the legal professions around the world and their regulators asked the question of what is it that we are trying to accomplish with regulation and what is it that we want lawyers to serve. We're not going to be able to stop these forces of technology and globalization, but if we really focus on what it is that's important to us, what we want to preserve, what we want to achieve, I think it will make us more deliberative and more thoughtful going forward. The UK did this in their Legal Services Act. A number of other jurisdictions have done it. But for example, in the US, I don't think we've memorialized this on paper in the way that we really need to. And I think that a number of jurisdictions around the world might find it a useful exercise to say the access to justice, the role to the courts, and other things that we think are so fundamental, preserving the rule of law, that as these developments swirl around us, we will act in such a way that those are preserved.
The point, I think, is that there are modern areas of expertise like communications, insurance, banking, admiralty, and multiple forms of investment, which do require specialized knowledge even as far as the legal community is concerned. I completely agree with David that leadership skills, even executive coaching, decision-making, all this may have to be a part of a lawyer's repertoire in the modern world. But I think at the same time, I would say that a note of caution has to be sounded that in countries where the liberalization in the name of services may itself be a subterfuge for extinguishing shall we say, fundamental access to justice is a very serious concern. You must appreciate that the attitude of a lawyer, a constitutional lawyer, who is practicing in India in respect of something like the Bhopal gas tragedy would be completely different from the attitude of a lawyer who is practicing in any other jurisdiction. And therefore we must appreciate that there are many tools of negotiation, mediation, plea bargaining, which may be available, which may be absolutely first rate. Many of the best systems of law are in the continental systems. We follow, for instance, in our constitution, the framework of the German constitution, which very few people know, that it's actually the German constitution whose framework we've followed. But I think we need to bear in mind that this cultural, or shall we say, historical context is not one of resistance for change. It is not one for shutting the doors, but it is one where there must be no fundamental compromise with society itself. That is the concern.
Thank you. Claudio Dorraga from Santiago, Chile. Well, please, if you want to speak,
I would
just
like
raise
to
your
ask
hand. I'm
the
going to
panel
note.
if we will hear the following dialogue in the near future. And this thing goes like this. I'm speaking with call center lawyers of the world. Yes, sir. You will be recorded for control of quality. Yes, sir. What do you want? I want to lease my house. Okay. In which country do you live? In Chile. Ah, okay. I will mail you a contract form. You fit the details. Oh, thanks. How much do I owe you? $30. Okay, thank you.
First of all, that was extremely clever. And second of all, it is not far-fetched. And third of all, as we think about it, I guess this is what I'd urge. We ought not to compare that reality to the reality of having the distinguished lawyer who just spoke do the lease, because that's not the comparison. If the comparison were, if we really thought that there was a realistic world in which everyone who had a legal problem could get a lawyer as good as the lawyers in this room, then many of the other solutions might not seem very attractive. But the realistic solution is no help or only self-help without any guidance. Most of the legal problems, even in my country, which I think has more lawyers than any other, and if not, we certainly rival the top, that most, not just poor people, most middle-income people cannot afford a lawyer. And I tell my students, even my students, I say, it will be a very long time before you will be able to afford yourself if you have a legal problem. Think about that. And that means that, and that gap will not be closed by governments. I don't know any government that is increasing spending on legal services for the poor, and certainly not the middle class. It's not going to be solved completely by pro bono, though I've just spoken in favor of pro bono, and it's very important. It's going to be solved by figuring out how to use the forces of the market, of technology, of innovation, to provide at least a basic level of access to people in a range of areas. Now, I agree with Laurel totally. We have to be very careful. We have to think, what are the values that are being gained? What are the values that are being lost? What are the risks? But I don't think that we can close off a discussion of these things or act as though the alternative is a fully qualified lawyer who will help everyone with their legal problems, because that alternative does not exist.
Just add,
Oh, sorry, please, go ahead, Laura.
I was just going to say, an exercise that I often do is to ask my students how many of them have a will, how many of them have a financial power of attorney, and how many of them have a healthcare power of attorney. And you would be amazed at the number of students, overwhelmingly, who do not. And it's not just money, although money is a big issue, but it's also issues of intimidation and familiarity and access. So I think we have a long way to go, certainly in my country, and I think around the world, in making sure that legal services that really everybody should have are much more widely distributed.
Thank you. Sir, please. Could you identify yourself, please?
Yes, good afternoon, everyone. Carlos Taboada from Consortium Centroamérica Abogados in Nicaragua, but also professor at INIDEM Business Law School in Panama. I wanted just to congratulate the panel. It's been a great session here at Harvard Law School, and I'm very enthusiastic about all the efforts and in the changes in the legal education trends. I've been following not only the follow-ups on the Carnegie report, but also the work did last 2 years ago, sponsored by Harvard Law School and New York Law School with all the deans.
Future Ed, we called it.
Yeah.
Yes, I remember that. And I just wanted to share a quick, what we have been doing in Latin America. At INIDEM, we got together partners from leading law firms, and we did an extensive survey from Mexico to Argentina, asking partners what they were expecting from their associates, managers what they were expecting from their lawyers, and lawyers what they were expecting from their education. And that's how we designed our programs. So we could tap into the problem. We found throughout Latin America the problem that law schools were not, law students were coming out of law school without knowing how to write contracts. So that was a huge problem. And it's a big challenge for all the profession and the law schools on how to adapt for this new world. So I would appreciate, especially for the professors, your views on how do you see this trend and what is being done about it here after those initiatives. Thank you.
Thank you. I'll say a word, and then Laurel, I'm very interested. I learn always when Laurel speaks, although some of it is scary. So this is a huge challenge, and here's where all of you have a right to look at us and legal education and ask, how are we adapting to this world? So let me say just a couple of very quick things. One is that we know that we need to have a broader array of skills that we teach lawyers. So, you know, the clinical movement, which started in my country in the 1960s, many of your countries, it's now becoming very important. The thing that's happened here at Harvard Law School, actually we just had a wonderful lunch with a justice from the Japanese Supreme Court who is here visiting us, and he wanted to see the clinics. And I told him that when I was a law student, which, as I tell my students, was in the last century, but not the century before last, we only had one clinic. Now we have something like 18 different clinics in a variety of different areas. The problems are clinics are very expensive, and they're a very expensive mode of legal education. So second, we've tried to move towards simulated learning for students. So we teach a course which the dean actually helped to pioneer, and I was one of the founders of, called the Problem Solving Workshop, in which we try to teach students something about contract drafting and contract interpretation. But I think we're going to have to get much more creative, and we're going to have to think how to use online learning, you know, online tools, the internet, various forms of practice where students can actually do things not in a classroom setting. And we need to connect that with the kind of professional development and training that's happening in other parts of the world. So the biggest growing sector of legal education is not law schools. It's for-profit legal education that's being offered by a whole variety of providers around the world. And so my plea is that we ought to not think about that as competition, but think about it as a way that we can link together and learn from various different ways where information can be provided to prepare people to be lifelong learners. Because, of course, learning can't stop when we're in law school.
I'll just say that I can mostly speak to academia in the U.S. And I think but I suspect because of friends elsewhere that this is also true elsewhere in the world. I think academia is getting it, and that we need to provide more of a connection. I'm not sure you're really going to want somebody on day one on the job drafting a contract with no supervision. But I think that we can be doing more than we have been doing traditionally. And I'll give you two comments. One is, I sort of get it. I have sitting on my desk when I go back to the office, I planned to submit to our curriculum committee a new course called The Legal Profession in the 21st Century that builds on some of the best parts of courses that I've seen elsewhere in the country, at Indiana, at UC Irvine, at Harvard, at Denver, and the Law Without Walls program, which has been incredibly innovative. And I think, you know, you get incremental change by people changing their curriculum. The second thing that I'll mention is, while I was here in Boston, I met with two lawyers from the IBA Law Firm Management Committee, and was told that that's now the biggest committee in the IBA, and that they have a legal education initiative in which they are trying to reach out to university legal education and law school programs and bring in a group of lawyers to talk about what it is that
mentoring program.
Yeah, that lawyers need, and really a half day or maybe a smaller segment to fit our programming. I would say that as an academic, inertia is a powerful force. And it's easy to do what you've always done. So if you feel like academia is not giving you what you need, I would encourage you to reach out to the law schools in your jurisdiction and offer your services. We're usually thrilled if somebody says, we would like to come in and tell you about our experiences and what we're looking for and what you're doing well and what you could do better. So I'd encourage you to reach out.
Okay, I have 7 people waiting to make questions. We have exactly 2 minutes and 33 seconds left.
We could go a little
but we can go a little bit longer. But I would then say, let's limit our questions to very short interventions. And then I would say one of you only answers, okay?
Perfect.
Because otherwise we are not going to be able to give them all the opportunity to speak. Sir, please. You are the next. You can go to the mic.
I'm putting a question because I have no answer to that question. I'm a first-generation lawyer. I was not intending to be a law practitioner, but Providence made me a lawyer. I qualified before completing age of 21 years, and therefore I was not admitted to the bar, and I joined a law firm, the oldest and the largest law firm in Mumbai, as an article clerk. I'm running 88th year, and I've been in profession for 59 years.
Wow. First of all, yes.
I have 4 children, 3 of them are married, and between 7 of them, 6 are practicing lawyers. But our first grandson is about to join law course. And I was wondering as to what will happen to his future. We are talking of our future. Well, I am an Indian lawyer, a successful Indian lawyer at that. I'm a good common law lawyer because when I go to England and handle my matters there, people do acknowledge me as a good common law lawyer. When I sit as a member of the International Court of Arbitration at Paris, I am accepted as a good international lawyer. But I am not a global lawyer. Now, what is it that will happen? Today, we have differences. We measure those differences. We try to build those bridges. We try to cross those bridges. But before we can completely cross, we find that new differences are developing. Now, therefore, the best academic institution represented today and the best law association represented today must give me a solution as to how the new crop of lawyers, of whom my grandson will be the first one, will have the seeds of a good global lawyer. It will be a wonderful thing to do. But about wonderful things, it has been said that when you wonder how to do it, you do it and wonder how you did it. Thank you.
Thank you very much, sir. Wonderful intervention. Thank you. So who wants to comment on that? Gopal.
Gopal, go ahead.
I think the answer to that is actually in what David and Terry mentioned, which is there has to be a fusion of education, legal education, on a continuing basis, which must have innovative, modern, and outcomes-based approach. I was extremely impressed that in Australia they shifted to what is called an outcomes-based approach. And it is very necessary even for legal education to have an outcomes-based approach, while acknowledging that you have to draw a balance between the development of the persona or the personality of a lawyer as an individual unit in society, and yet be able to account for what I think is an outcomes approach. And this is where the skill of academics is completely necessary. If one thing academics have proved, it is that their representation in the judiciary should be imperative. I have seen this in the UK Supreme Court, with Baroness Hale being there. I think she has made an extraordinary difference to the quality of adjudication, to the quality of perception and independence of thinking. And I don't see why there should not be a partnership between what my very eminent and distinguished friend from Bombay said, that there should be a collaboration, which I suggested to the IBA yesterday, between Harvard and IBA for continuing legal education in multiple disciplines, which are freely available, which also have the most innovative characteristics. And it should be made mandatory for continuing to practice as a lawyer, including what Mr. Parekh described. If you are a lawyer practicing in court or a tribunal or in any sectoral domain which needs expertise, you must have credits of continuing legal education. It is imperative.
Thank you. So could you please identify yourself and also say to whom your question is directed? There was a gentleman with a papillon tie on there that he would be the next, but I think he left. Who was? With a papillon like this.
Bow tie.
No, it's left. It's you. Please come. You're the next. Please come to the mic.
Please.
Go ahead.
Jeppe Skadhauge, the Danish Bar and Law Society, and also a partner of Brun and Jejle Copenhagen. Are there any lessons to be learned for the legal profession from the causes of the financial crisis? I would like David to give a brief reply to this. The causes seems to be a combination of technology, human behavior and regulation, or perhaps lack of regulation? Thank you.
Thank you for such a simple question. I think there are many. I'll just say a couple very quickly. I do think that personally, there were a lot of terrific lawyers and law firms that blessed a lot of financial transactions, just as a lot of terrific accountants and a lot of terrific rating agencies that blessed a lot of financial transactions without understanding them. And I think that's the deepest point. I don't think there was virulence. I don't think there was conscious malfeasance for the most part. Maybe there was. There isn't anything. But I think one of our biggest challenges is that as the work we do becomes exactly more multidisciplinary and complex, as we are engaged in making disclosures on transactions that are increasingly difficult, it really does raise a challenge that I think many people have said, which is how do we prepare lawyers for doing this? I teach a course, which I just taught yesterday, with, it's called Challenges of a General Counsel. I teach it with Ben Heinemann, the legendary general counsel of General Electric, and Mike Solander, who's the current general counsel of Ernst & Young. And it's an example of something I think that could be done in lots of jurisdictions, of combining the knowledge of a very experienced, seasoned practitioner with a current practitioner with an academic who thinks about these challenges. And we were teaching Enron. So before we had the current financial crisis, we had the 2001 crisis in the Enron company. And one of the big challenges there was that lawyers were being asked to opine for transactions that even perhaps the accountants or even Enron, most of the people at Enron didn't understand. That is a real challenge, and I think that's going to happen to us more and more, and it will require what Gopal just said, which is there has to be lifelong learning, there has to be a commitment on the behalf of the profession to understand enough of the other disciplines when we are asked to be in a position to certify something to a regulator, to the public, to ourselves, that we know enough to be able to say it with the kind of confidence that I think we would all like to have.
Brilliant. Thank you. Brilliant. Next would be you, please. And then
Carol,
it's you.
Please.
I'm sorry, I missed one. But
So this is a fascinating discussion and wonderful remarks by all of you. And I have a question.
First, you're Carol Silver,
Carol
one of the
Silver.
leading authorities on global lawyering and LLM
you,
programs.
right?
Yeah.
And I was reading today in the New York Times an article about what companies are doing, which is called inverting. And essentially, it's relocating for purposes of getting better tax treatment, better support from law for management, strategy, growth, and going to another country. And it occurred to me that, of course, clients drive most of what we do and most of what you see in terms of global growth. And so is this going to drive lawyers shucking their national identity? And what will that look like? So I'm not sure who this is a question for, but it's actually a question in all seriousness.
Mm-hmm.
Jonathan, you want to take it? Because you've been
The questions
out
are getting
there in
more
this
difficult,
world.
and then I get handed them. I think one of the challenges of technology is that, which is the same thing, the borders are disappearing, and the regulators are by and large national, and how can they reach across the borders to make sure that they're regulating still their own members? So I think I'm agreeing with you that it is a big problem, and I think it's one of the challenges of bars that the very national regulation that we have is not fit for the world in which not only lawyers move, but they don't have to move because the borders have disappeared anywhere. Within the EU, we have our own solutions. Lawyers can cross the border very easily, but there are laws which regulate it, and the bars are in touch with each other, and so that it works. But I think that it is, I throw up my hands and agree with you and say it is a serious problem about how bars, we have it with multi-jurisdictional law firms, about how bars, which are national bodies, regulate international or stateless law practice. There is at present no answer, and we have to work towards it.
Please go ahead.
My name is Juan Jose Alcero. I come from Honduras, a Central American country and law firm. A quick question on, we had a session yesterday on core competencies for lawyers, and one of the things that kept coming in is the need of ethics and integrity in lawyers. And we were asking how can law schools and probably law firms try to train and develop their people on this ethics and integrity. Probably the question to Mr. David and to Horacio. Can this be done? Because it's a virtue, something you have, but at the same time, how can law schools and law firms help on that in ethics and integrity in the legal profession?
So when I first got into the teaching of law in 1986, there was a big debate. I wanted to teach ethics, and there was a big debate about whether ethics could be taught. I always thought that, like many of these big debates, that it was missing the point. Of course, there's a certain kind of character or virtue that who knows where we get it from, your mother's knee, your genes, your environment. But that's not really what we're talking about. What we ought to be, it's that you have or you don't have. The question is, how do we help people identify difficult situations beforehand or while they're in them, and then what tools do we give them to work through them? So again, I'll just come back to this course that I teach with these two wonderful general counsels. And each of these, we sort of go from one, scandal from the headlines to the next. We're doing the HP scandal. We're doing Google in China. We're doing, as I said, Enron. We're doing the problem of sourcing in countries where child labor laws are ambiguous. And each time the question is, how should the general counsel think about this problem? Sometimes we have an actual general counsel whose conduct we can look at, and we always start by saying it's easy to take it apart, 20/20 hindsight. It was much more difficult when you were in the problem. We try to understand the pressures that person was under, and we try to give the students a framework for thinking about the problem and some concrete steps that can be taken beforehand, institutional design, about how to set up, for example, in Enron's case, Enron had 0 hotline, employee misconduct reporting. They didn't have any procedures in place, how to put those kinds of procedures in place, how to design them, what are the strengths and weaknesses of certain kinds of procedures, and then we put them in the role and say, okay, I'm the CEO, you're the general counsel, please come tell me how you're going to have to take this allegation you just got against me to the board of directors. And we say, how are you going to say that? And it's no guarantee that they're going to be ethical when we turn them out, but they're going to have a lot of tools. This is what we do. We teach people how to reason through complex problems. And the first question that Ben, who has much more credibility about this than me, says that when the students start talking about the FCPA or the securities laws or whatever, he said, no, here's the first question I want you to ask. Is it right? Do you think that's right? Now, that might not be the last question we ask, but we have to ask that question. And I think sometimes in legal education that we teach students to be so focused on the technical aspects that we discourage them from asking the fundamental question of whether or not they think it's right. And from there, how do we move forward? So I think, yes, we can teach it, and not only can we teach it, we have an obligation to teach it, not just in law schools, but every time you deal with one of your younger lawyers, every time if you're a judge, you're in a court proceeding, you have an opportunity to help people understand what's right and how to accomplish it.
Thank you very much. Very good. Very good. You, sir, please.
Thank you very much. My comment.
Oh, sorry.
Yeah. No, but because I didn't have you. But it's okay. It's okay. It's okay. I'll put it in the list. Let me just obey the list here. Go ahead, and then it's Bruce, please.
I'm called Birunja. I'm from Uganda. My comment is derived from David, who raised an issue about moving from professionalism to business. There was a time when it was questionable whether lawyers were professionals or whether they are business persons. And that was taken further to say that maybe it's not such a good thing that in some areas, for example, in constitutional law or human rights law, it's so important to move into the business attitude. My comment was that it's so important for lawyers, whether they are defending individuals, whether they're human rights lawyers or whether they are constitutional lawyers, to behave as a business. I don't think it's necessarily wrong to do business. We are primarily in business. And it doesn't mean that once you are doing business, you have no ethics. If you fail to do your legal work as a business, you'll definitely be overwhelmed and you'll be swept aside. It doesn't mean you should lack ethics. That was just my comment.
Mm-hmm. Thank you. Mm-hmm. No, unfortunately, I think it's 5:45, sir. I'm very sorry. We are going to. This is going to be the last question, the one that Bruce is going to pose afterwards, and because there are many others registered.
Certainly.
And then the speakers are going to be around. We're going to have a cup of wine offered by the
the Australians have brought wine. You don't want to miss it.
Wine. So let me end with Bruce. I'm very sorry, sir. Is that I have many other names here, and it would be unfair to.
Sure.
Thank you very much. So Bruce is. Please go ahead.
Who is, by the way, the best dressed man in the room?
That's very kind. For those who can't see me, I'm the bloke wearing the skirt. I'm president of Law Society of Scotland. I think the question I'll pose, or the issue I'll pose, is around access to and accessibility of justice. We've heard from Dr. Albright's opening address at this conference, and been repeated here and emphasized the disparity and the growing disparity and difficulty around that. It is both a difficulty for society, but it also presents an opportunity for lawyers, for those lawyers who might feel that their business is going to be threatened. We have heard that people find accessing a lawyer sometimes intimidating intellectually, financially, and even just in the matter of convenience. One way of getting around that is to look at what you must do as a lawyer, structure the really important thing that somebody needs, and reinvent how you deliver and where and when and in which sectors of society. Because lawyers have always done a very great deal of pro bono work as part of doing their daily job, and we don't make a song and dance about it, but it's a very important part of who we are, what we do, and why we do it. It is time that we started emphasizing that ourselves and finding new ways of delivering these vital services. I know it's a bit challenging, but it can be done. I've seen people do it in Scotland. I've opened new law services doing it. It makes a transformational difference to people in a community, many of whom will never have been to see a lawyer before. Secondly, pro bono, that is part of it. One of the things I would just like to raise as a question is how much pro bono is delivered through law clinics staffed by students and educational institutions. It's quite big in Scotland, it's quite big in the UK. We now have structured charities, LawWorks and LawWorks Scotland in the UK. This has proved very successful in delivering more pro bono to more people. Students and young lawyers learn very valuable skills in life and skills in the law and how to deliver services and meet client needs. So there is a very strong educational aspect to this as well. And I would just like to ask to what extent the panel thinks that that is something that could be further extended, because we need to be taking small steps before we take the large ones in addressing this issue. Thank you.
Go ahead.
I think it's an excellent point, and this is exactly where mandatory legal education on ethics, which David spoke about, that is, you simulate in advance, in anticipation, various problems, give them design, and give an opportunity to an intending practitioner to go through the process of checking out what is right and wrong. This is absolutely essential. And this is something which the best general counsel of the most leading corporations in America have told me, that it is this training which helped them to stand up in a board of directors meeting, challenge everybody, and put down their voice in unequivocal terms. This is one. The second point which was mentioned, and it's very relevant, particularly in the context of what Lord Hope mentioned on more than one occasion in Scotland, is that there is a certain duality of our profession. Undoubtedly, it has to be prosperous. We're not talking about an impecunious profession at all. We are talking about a profession which must be able to survive on itself by its own earnings without any kind of overt intervention. But at the same time, the challenges which are faced have to be shouldered by somebody in society. And we're all living in multiple democracies where the state, within quotes, is no longer the Platonic or the utopian state. It's ultimately a profession which will have to come forward and take the challenge. I only wish to add that every regulator, and I've suggested it when I was the chairman of my regulatory bar, that there must be a mandatory certification before a person is commissioned to practice. One, of course, was an examination, which I was able to introduce in spite of very, very stiff opposition. But the other one was to have, again, education in ethics. And that must be simulated education so that the person knows on the ground how strongly he has to stand. Yes. And it is perfectly possible, and I think what you mentioned with reference to the possibilities in Scotland, and in Scotland is an excellent example. I'm aware of the initiatives taken by the Law Society very recently about dealing with mentally challenged people, dealing with probation officers, areas of domestic violence which were hitherto unattended. I think it's extraordinary. So we as lawyers can always combine, I think, this fair balance between aspirations in the economic sense and also social challenges and responsibilities.
Well, I was just going to say, I was going to close, but are you going to close?
No, go ahead.
All right. So what I was going to say is we've certainly had more than a fair balance of ideas and insight and dialogue here. You have been an unbelievable group to come to visit with us on behalf of the entire Harvard Law School faculty and family. I want to thank each and every one of you for being here, and please don't be strangers. If you come to Harvard again, let us know. If you have ideas, let us know. I think I speak for all of the panelists here, because this is a vital conversation, because we are a vital profession. And we shouldn't shy away from that or be afraid to say that. But then we have to make it vital in the world of the 21st century. Thank you all for everything. Thank you for, oops, somebody gave me a long note. I'll read that later. Thank you all. There's a reception.
I just wanted to add one thing. I've been around the IBA since '81. I was registered to the IBA in '81. I never saw a gathering that finishes with this number. Yeah. And for me, and for me, I must say, maybe immodestly, but I'm not modest at all. Actually, I always have the impression that for me to be perfect, I just need to be a little bit more modest. I think this was the best session that I ever experienced in the IBA. So I please ask you to enthusiastically help me thanking David and the panel.
Thank you. Thank you. Okay. Let's drink and eat.